My name is Ralph Smith, and for those of you who've seen some of our earlier videos on events that have been occurring around the federal government in the last month or so, you probably already have seen a couple of our videos. We've been viewed by a few 100,000 people, and we appreciate the confidence people have in looking to FedSmith for information on the government reorganization, resizing, restructuring, optimization, whatever it is you choose to call it. Our goal, I'm an author with FedSmith, and in writing articles or doing videos, our goal is to try to explain what's going on. It's not to take a political position one way or the other, for or against, but just to say this is what's happening, this is how how it's occurring, this is how it may be able to occur under the Civil Service Reform Act. This video today is designed to explain something about the Civil Service Reform Act. That's important to those people who are being terminated, uh, probably important to some who are left because the Civil Service Reform Act controls a lot of what's going on. FedSmith did a video on probationary employees and what was lying ahead for them under this reorganization project that's going on. In doing videos, especially some that are viewed by tens of thousands of people, it's easy to make a comment, and actually we appreciate the comments. We learn from it. We find out what people like, what they don't like. Some of the comments are very good. Some are not very favorable. And that's just the way it is when you're dealing with a large audience. We try to be objective, straightforward, and that's what the purpose is. I'm not a lawyer. I have worked with the CSRA. Actually, the first training class I did was on the CSRA for a group of union officials before it became law. The Civil Service Reform Act was passed in 1978, and I was working at the time for part of the Labor Department, which became the Federal Labor Relations Authority. Shortly after CSRA was passed, I got a promotion and went to a new agency, at least a newly renamed agency, called the Office of Personnel Management. And my job was to go around the country, largely in the DC area, doing training classes on what CSRA is, what it was, what it stood for, how it came to pass. A lot of people now, in filing complaints, are arguing that the CSRA is unfair, it's being interpreted incorrectly, the government is interpreting and applying it illegally, etc. Uh, we'll find out from the court cases eventually if they're right or what's right. The way it's being applied may be unfair. I'm not going to argue that one way or the other. It's a value judgment. I can explain how and why the courts that have issued decisions so far have sided in favor of the government. The Civil Service Reform Act, as I said, became a law in 1978, and part of it was designed to make it easier to fire federal employees. Jimmy Carter went around the country arguing in favor of the CSRA. With him in a lot of these performances was the president of the American Federation of Government Employees. At the time, that was a man by the name of Ken Blaylock. I've met Ken Blaylock, uh, not as a friend, I certainly didn't know him well, but enough to form an impression of him. Ken was a plumber working for the Air Force in South Alabama and became the president of AFGE. And I don't mean that as an insult to him or his background or to plumbers. Uh, you don't become president of a national union without having a lot going for you. And a lot of what he had nothing to do with having or not having a college degree. The man had a lot of raw intelligence, strong personality, analytical ability. And when I suspect the President of the United States asked him to go around the country, be on national TV, and support his efforts to reorganize, reform, restructure government under President Carter, it was probably a temptation that was hard to resist, and he didn't resist it. And AFGE's national president was part of the reason the CSRA was passed. So I'm guessing AFGE had some influence in how it was written and what it did. Their goal at the time, to put it in perspective, was the Federal Labor Relations Program was run under an executive order, issued first by President Kennedy, modified by President Nixon, but it was still an executive order. And as most of the viewers know, an executive order can be changed by whoever the next president is. They really wanted labor relations to become law, and it did. That wasn't necessarily good for Mr. Blaylock's career. He had some problems dealing with a lot of union people who didn't like the CSRA. And in part, you may be seeing now why some of them thought it was a mistake. The CSRA was designed to make it easier to fire federal employees. That, based on performance largely, several authors who are more knowledgeable, more experienced than I am, involved with performance appraisal, have said with good justification the law failed in that respect. It didn't make it easier ultimately, it became probably more difficult. Performance appraisal plans, critical elements of a performance plan, appeal rights in firing a career employee all became very lengthy, time consuming, hard to do. Most federal supervisors, once they had some knowledge of how the system worked, would rather, in many cases, leave a person sitting in an office reading a newspaper all day, even not doing anything related to his federal job, because it was quicker, it was easier, it was less stressful. He slept better at night not having to deal with the person. So a lot of times it was just ignored. It didn't work. But part of what the CSRA did also was it created a couple of new agencies. I mentioned the Office of Personnel Management, which was the Civil Service Commission, but two new agencies were created: the FLRA, Federal Labor Relations Authority, and the Merit Systems Protection Board. And that's important because of what's happening now with some of the cases going to court. Two cases in the last few days have not gone in favor of the people who were suing the government, largely a consortium of unions. And the reason is because the CSRA created a path for resolving complaints. A union that has a complaint about how the labor relations statute or a labor relations issue goes to the Federal Labor Relations Authority, not directly into federal court. Both decisions that have come out, the judge has specifically cited the CSRA as why, one of the reasons why, he was not ruling in favor of the positions that the unions or the plaintiffs were articulating. They have to go to the Federal Labor Relations Authority. Now, a probationary employee doesn't have the same appeal rights as a career employee. They are much more limited. Specifically, they can only appeal certain things. If you're terminated as a probationary employee, you can only appeal based on things such as I was fired because of my political affiliation or my political views. I was fired because of my marital status. I was fired for discriminatory reasons, my race, my color, my religion, those types of things. That is how you get a case before the MSPB, possibly before the Office of Special Counsel, if you're a probationary employee who's been fired. Now, what's happening, according to various reports that have come out, is people are being fired because of poor performance as a probationary employee. And they're citing, I have gotten good performance reviews, good comments from my supervisor or supervisors based on my performance during the time I've been with this federal agency. But yet I've been fired because of poor performance. So they're lying. That's not the reason. Well, we'll see how that works out. Going directly into federal court is going to be tough because the CSRA says the way you file a case, if you're a probationary employee or a career employee, is typically you go to the MSPB. It can go to the Office of Special Counsel for occasionally for some reasons that don't appear to be applicable here, but possibly they are. We'll see what happens, what's coming out in the allegations that people are making. And supposedly tens of thousands of people have been fired or are in the process of being fired. Many of those are probationary employees. So the people, the lawyers making the decision, where do we go to file this appeal, have to decide where do they go. And so far, they've gone to federal court. Makes sense. Some class actions are being filed. A class action that is filed, usually it goes into federal court. And that appears to be what the attorneys that are filing these cases are going to be doing. But that remains to be seen. If they continue to go there, it remains to be seen how their cases come out. One of the arguments being made is that the way the government has handled it is unfair, that it wasn't based on performance, it was based on some other reason. That's the kind of argument that might be made for a career employee going to the MSPB. Unfairness probably doesn't have a lot to do with it. It could be unfair that you're fired. It probably is unfair that you were fired, especially if you're doing a good job. But because the limited appeal rights exist, especially for probationary employees, a court is likely to say you only have limited appeal rights based on these topics. Some arguments being made are that in effect the government was trying to avoid a RIF, reduction in force, and perhaps that's true. In our earlier video, we said it's quicker, it's easier to fire a probationary employee, and it's likely that's why MSPB was asking federal agencies, how many probationary employees do you have on board? So in effect, if they could fire 100 or 200,000 people as a probationary employee, instead of going through the RIF procedures, it would be a lot quicker and easier. In the comments, some people have asked, were you working with the Office of Personnel Management, OPM, or with the administration in some way when you did your first video because you predicted this would come? No, we weren't working with anybody on it. I've got a lot of experience in working with the Civil Service Reform Act, so we know what it says, we know how it applies. We know the Supreme Court has it in the past upheld the CSRA by limiting the appeal rights in order to make it more efficient based on the specific areas that the MSPB or the FLRA will cover. So there's no political agenda. It's just a person who knows the system could look at it and see, and the people at OPM or elsewhere who were looking at the system obviously know how it works. So they were probably using the probationary system as a way to downsize, restructure, optimize the government. That's how it can work. That may not be how it was designed to work. Maybe the people who passed it didn't even think of that happening. But that happens with a law that passes. But the judges so far are saying, I have to interpret and apply the law that exists, not as somebody else thinks it should have been written. So there we are. That's where we stand. We've heard from a lot of probationary employees who are really hurt financially, emotionally by what's happened. The federal government has been thought of as a career type position. Once you get into working for the federal government, a lot of people stay 30 or 40, even 45 years. But that's not happening right now. It's becoming a less pleasant place to work. That appears to be part of what the administration wants to do to reduce the size of government. So that's what you're dealing with. We hope you find this video to be useful, instructive, educational, and we wish you the best of luck. Thank you for watching.